Hello and welcome to Crane Talk, a podcast that covers all things cranes, rigging, and heavy iron. My name is Isaac Smith and I'm joined by three experts in the industry, Ron Thompson, Gene Greiner, and today we have a special guest. Would one of you like to introduce him for us?
Well, it's a pleasure. We heard Lee speak back in September at the Texas Crane Association, and our guest is Lee Parsley. He is the president for Texas for Lawsuit Reform. He is also their general counsel, and somehow, Lee, you got the president gig. So congratulations on that. But we're fortunate to have Lee as being an advocate for our industry, especially in Texas on lawsuit reform. I think Lee's bio, I think he was instrumental in some of the reforms on attorney advertising in 2019, the trucking lawsuit reform bill in 21, and I didn't know are you involved with this new Texas Business Court, Lee?
Yes, we, Texans for Lawsuit Reform, were the leading advocate for the Texas Business Court in the Capitol in 2023, and we're real pleased about how that's going. The court is up and running, and it gives a place for business-to-business litigation to happen, so you get out of the courtrooms in Harris and Dallas County, which are bogged down with family law and some criminal cases, and so a business-to-business dispute can end up at the bottom of the docket, and now you've got at least a chance to go to a court system that focuses on that kind of litigation. So we're real happy about that.
I also see on your bio, you served as Texas Supreme Court rules attorney.
Yeah.
That to me sounds like that's a big time deal.
Well, there's an interesting story there. I had been working for a big law firm out of Dallas. I was in the Austin office, but that law firm crashed. And so then I was looking around for a job because I was young and had a family. And I got a chance to go be the first rules attorney at the Supreme Court. The court drafts rules of civil procedure, appellate procedure, and rules of evidence. And the rules that had existed were decades and decades old. And so I got hired to go update those rules. And it was a great job. The Supreme Court's a great place to work. I loved it. I did that about 3.5 years. And it's how I learned to write rules. And rules and statutes are kind of the same thing, frankly. And so it gave me an expertise in statutory drafting that I employ at Texans for Lawsuit Reform, because really a big part of my job is writing statutes that we go to the legislature and ask them to enact. And it was great training and a great job.
So we're going to get into this. House Bill 19 is a sort of a lawsuit abuse reform bill. I think maybe authored by Jeff Leach, Plano. And it's a great bill. And Lee talked about this at the Texas Crane Association. It's a great bill, great statute, but it's not working. So Lee, we want you to kind of comment on that, because it was interesting comments you made back at TCOA back in September.
Well, House Bill 19, you're right. Jeff Leach out of Collin County was the House author of the bill. And the idea, it applied to commercial vehicle lawsuits. Commercial vehicles is defined very broadly to mean anything from the big 18-wheelers out on the highway down to the flower delivery service and pool service vans that are running around your towns. Anything that's in commercial operation, not a personal vehicle, involved in a lawsuit is now governed by that law that Jeff Leach sponsored in 2021. And the idea was that, first of all, if you are the owner of a commercial vehicle and your vehicle is involved in an accident, well, they sue the driver of the vehicle for negligence and however he or she operated the vehicle. And then they sue the owner of the company for allegedly negligently entrusting the vehicle to the driver, negligently training, supervising the driver. And so you get these actions that are both against the driver and against the company. And the plaintiff lawyers love how they maximize their awards in these cases is they treat the company like it is a threat to humanity. So they're trying to paint the picture that the company has bad employment practices, and so they put bad drivers behind the wheel, and they have bad safety practices and bad equipment. And so they're just a threat to society, and you as a member of the jury should punish them for being a threat to society. So the bill was designed to really implement a long existing Texas law, which is to say, if you are the owner of that company and you admit that that driver was your driver operating your vehicle for your purposes at the time of the accident, then the only claim that survives in the lawsuit is the one against the driver for negligently operating the vehicle. And then you, the owner, if the driver was negligent, you, the owner, pay all the damages. You, by saying that was my driver doing his job, you own all the damages that are awarded. Simplifies trial. It's been the law in Texas forever, but the trial judges all over the state were just ignoring it. So House Bill 19 was just to try to implement that old standing law that once you admit this is my driver doing his job, then you own all that liability. And it's the way the law should be. It's the way the law is in many other states, but it's what our trial judges were just ignoring it. So Jeff Leach decided, well, let's put it into the statute. Let's make it clear that that's the way it has to happen. And then also in that same bill was a provision that's actually been pretty handy, pretty helpful. Many of these lawsuits, the plaintiff's lawyers, if you tried to show a photograph of the collision, or many 18-wheelers now have video, and so they'll have an actual video of the collision. And the trial judges all over Texas wouldn't let the trucking company put into evidence the video of the collision or a photograph of the collision if there wasn't very much damage. So it was just a little fender bender. Then the plaintiff's attorney was saying, oh, my client is just badly hurt. They're never going to lift up their grandchild again. They're in terrible shape. And the video was showing a little bitty fender bender. Well, the trial judges would just exclude the video. So another part of that bill was to say you must let the jury see the photographs and the videos of these accidents. So that's basically how the bill worked.
There was also the whole idea of they wouldn't let the jury understand that there was a relationship between the doctors and the attorneys.
Right.
And then there was also a big fight about, publishing to the jury's projected medical expenses versus actual medical expenses. Because a lot of that was, along with the reptilian theory, which we've talked about that on this podcast quite a bit, demonizing the employer and showing them as a threat to society, and it worked.
Yeah.
But there were a lot of components that in that bill they were hopeful to get into consideration in our court system, right?
So when you separate the negligent driver from the employer,
Mm-hmm.
the employer has to meet, 5 or 6 different things to say, okay, check, we did this, we did that, we did that. Is that happening, Lee? Are these cases being split out between the driver and, I guess, the employer and getting away from this negligent entrustment?
Yes and no. As I described the bill, you weren't supposed to be able to pursue those claims about negligent entrustment, negligent training, negligent hiring in the trial. And that was a little bit of an oversimplification. You could pursue those claims against the employer in the second phase of the trial. So the bill called for what in the law they call bifurcation, but basically it's to split the trial into 2 pieces. And you guys will be familiar with this, your audience will be, in the criminal context. So if you're charged with a crime, those cases are tried in 2 pieces. First, the first part of a criminal trial is, did you commit the crime? And the second part of a criminal trial, then the same jury, but you just take a break and you come back in after they decide if you committed the crime. And if you did, then they hear evidence about what your punishment should be. So criminal cases are tried in 2 halves. So this trucking bill was to try civil cases in 2 halves. The first half would be, did your employee cause the collision? Yes or no? What are the plaintiff's compensatory damages? How much did they miss work? How much are their medical bills? What gets them whole? And then the second half of the trial would be, then should the employer be punished using punitive damages for negligent entrustment of the vehicle to the employee? So we divided the case into 2 pieces. And that's really how Texas law should operate. It's how it operates in criminal cases. Nothing was really very unusual about that. On the House floor in 2021, they introduced an amendment that said that big truckers, sometimes wouldn't get that bifurcated two-part trial process. And that's caused House Bill 19 to be a little less effective than we had hoped for. And therefore, I think your people out there listening probably haven't seen the reduction in their insurance premiums that they hoped for, because they're still getting hammered pretty hard in the courtrooms of Texas because if they're operating the big rigs, 18-wheelers, the large commercial vehicles, then they're not getting that two-part trial process like they should be. And we'd love to go back in 2025 and fix that problem. We need to go back to the original intent of the bill, which is to separate it into two parts of a trial. And the first part of the trial is just who caused the collision, who ran the red light, the plaintiff or the truck driver, and what are the plaintiff's legitimate damages, medical damages, lost work damages, if the truck driver is who ran the red light. And then the second phase of the trial, you can accuse the company of being a horrible actor if you've got the evidence to support it. So that's how it ought to work, and we need to go back in and fix that bill in 2025. But you are right, Gene. The medical damages is an enormous fraud in the trial system today. We can get into that topic in a minute, but it's a mess, and we've got to deal with medical damages.
What other parts of that House Bill 19, Lee, that's not working that you're going to be addressing in 25?
We will go back, I hope, and take out that House floor amendment on that. And then the second thing we've got to do is medical damages, as Gene mentioned. Here's the way it works. You are in a fender bender. You'll start getting calls from lawyers or their case runners, and they'll say, "Hey, sign up with my lawyer." By the way, that's illegal. Not supposed to happen. Happens every day all over Texas. So you decide, okay, I'm going to sign up with one of these TV lawyers. You call them on the telephone. They get you to sign their contract. They're going to get 40 or 45% of whatever you recover. And the first thing they want you to do is go to their medical providers, chiropractors, sometimes physical therapists. And that their unwritten deal with these medical providers is to run up the medical bills as high as you can. So treat all the treatments you can give this person. Don't submit the claims to insurance for payment. Just send the bills to the lawyer and bill at the highest rate you can think of. And then if there's a lot of insurance in the background, if the trucking company's got a lot of insurance, then they'll send the person next to a pain management specialist. Again, pain management, lots of treatments, high bills, none of it paid by the insurance company, sent to the lawyer. And then many times you go from there to a back doctor who will diagnose that you've got some sort of spinal problem that's going to require surgery. He'll treat, run up the bill as high as they can. So they go to trial then with all of these unpaid medical bills. Fender bender with $300,000 worth of medical bills is typical today against an 18-wheeler company. And they'll say to the jury, the star witness will be the doctor who is the back doctor, and he'll get on the witness stand and he'll say, "Man, poor old Gene is never going to pick up his grandchild again. He's going to have a lifetime of pain and suffering and mental anguish, and you need to award him millions and millions of dollars for this pain and suffering he's feeling and for the medical bills that are unpaid." And that's how you get the big verdicts in Texas. And I'll tell you, it makes me mad. It's fraud. The doctors and the chiropractors who are involved in it are crooks, and the lawyers who are getting them to do it are just as crooked. And it is the state bar ought to disbar the lawyers, and the medical board ought to take away the license to the doctors. But day in and day out, it's happening all over Texas. And that's the way these cases are built, and that's how you're seeing the big verdicts.
Lee, I got a personal situation. About 5 weeks ago, I was T-boned by a F-450. He ran a stop sign, totaled my vehicle out. We filed a police report. 7 days, that police report was published after 7 days. And I got 2 phone calls and 2 text messages. And they were identifying themselves as advocate for accident victims. And so I actually took a phone call. I go, what are you doing? He goes, "We're wanting to know if you need any medical assistance. We can refer you to doctors. We can refer you to attorneys." I saw that up close and personal, and I said, "How did you get my contact information?" They said, "Well, the police report's public record. It had your phone number on it."
Oh, wow.
I saw it up close and personal, man.
That's happens to everyone. It's really a scam. It's they are out recruiting clients for the lawyers.
The other part that we talked about quite a bit on this podcast is the third-party financing for plaintiff lawyers. When they can go out and raise money on the private equity market or whoever it may be, promising 20% returns, and they're raising millions of dollars, and the insurance carrier puts up $50,000 for defense cost, who's going to win that case? And so the third-party financing, number one, I think it's an issue. Number two, they don't have to disclose they've got private investment money in funding a case.
Or what's the analogy? The insurance company is bringing a butter knife to a gunfight, right? They have no ability to have a backbone. I mean, that's one of the common, complaints we hear from our customers in the heavy construction, crane and rigging. They're not driving a lot of their stuff are cranes, right? They have the big trucks as well, but they want somebody to fight. They want to take it to the mat. They feel that they haven't done anything wrong, or they feel that they have a voice that's not being heard, and the insurance carrier is settling something that is in the best interest of the insurance carrier and ultimately in the best interest of the business owner, because that's the landscape that they have to operate in. And it makes everyone mad, and they're just like, well, wait a minute, why did you settle on this? Or why did you do that? And everything that Lee's talking about and what we've spoken about is really where that is, And then you have the judges. Lee, you mentioned a little while ago, even though House Bill 19 was passed, albeit, there was a portion of it that was taken out, towards the end there on the floor. But you mentioned the judges are still ignoring what's there, or at least some of them are, right? So there's a whole component there that is concerning. We spoke a couple of podcasts ago about judicial hellholes, and Dallas is one of them, right?
The Fifth Circuit, yeah.
Yeah, right. Yeah, the Fifth Circuit. Yeah. So, I don't know. That's the landscape. So
the appeal to the Fifth Circuit of Dallas, right? Fifth Circuit goes, we agree, we're going to allow all these jury, the anchoring comparisons, Lee will talk about that, where it has nothing to do with the actual economic damages and non-economic damages. Right. So we always had the old Texas Supreme Court that came in and go, wait a minute, you're not going to get away with this, Fifth Circuit. So with the recent election, that might have changed the landscape, Lee. I don't know. But I don't know what's happening in the local judges. The hellholes we saw were, and you mentioned it, Lee, San Antonio, Houston, Dallas, and East Texas, and some parts of South Texas.
Right.
And so that's got to change.
Let's start with the anchoring, which I think, as Gene mentioned, the biggest crane case right now, of course, was out of the Dallas trial courts, and was a crane collapse into an apartment building and killed someone. In that case in which someone was killed, the first of all, the first problem was that the plaintiff was allowed to file the case in a county court at law in Dallas and try it to a 6-person jury. So lots of people probably are not familiar with Texas' judicial structure, but the county courts at law are supposed to handle kind of small cases that you try to 6-person juries. And then if you've got a big case, you try it to a 12-person jury in a district court. But some years ago, the legislature said the county courts at law in Dallas could hear any size case. And so the plaintiff lawyers in Dallas love to try these personal injury cases in front of a 6-person jury in a county court at law in Dallas. And that's that crane case. The lawyer in that case told the jury that they should consider the value of the person's life based on, for example, a $750 million fighter jet and a $500 million piece of art. So he was comparing, he was using things that have nothing to do with the crane collapse as comparison for damage awards in the case. And the jury awarded, 5 out of 6 jurors agreed to award $860 million for a single person's death in a crane collapse case. Now, there's nothing good about that. A person died, it's terrible, and their family's entitled to their day in court. But these references to paintings and fighter jets have never been appropriate in Texas court because they have nothing to do with the actual event. So the Texas Supreme Court did, in a different lawsuit, say that kind of anchoring, that's what we refer to it as, you anchor to something that's unrelated to the case. You anchor to the value of something that completely unrelated to the case. The Texas Supreme Court said that kind of anchoring can't be done, period. It's improper, can't do it. So to the credit of the trial court in Dallas, that county court at law, it set aside the $860 million verdict, and that case is scheduled to go back to trial sometime early next year, I think. So they are retrying that case because it was just full of error about this anchoring process. But what that tells you a couple of things, that our trial court system, until corrected by the appellate courts, is not working very well. Just like you said, Ron, I mean, we've got problems in the Dallas trial courts, the Houston, San Antonio, some in South Texas and some in East Texas, where they should know that this kind of anchoring is wrong, but they were just letting plaintiffs' attorneys do it day in and day out in courtrooms across the state. So the appellate courts are critical to us. You've got to have a good Supreme Court that says, nope, that's not right, can't do it. And frankly, between the trial court and the Supreme Court are those intermediate appellate courts, like y'all been talking about, the one in Dallas, which is the 5th Court of Appeals in Dallas. And that Court of Appeals in Dallas has been just a rubber stamp for these bad ideas. So the trial court lets the plaintiff's attorney get away with whatever, anchoring or other bad ideas. The Court of Appeals in Dallas rubber stamps the judgment, yep, good by us, and then the Supreme Court has to fix it. So the voters of Texas did elect some new judges to the Dallas Court of Appeals in the last election cycle. There were 8 seats on that Court of Appeals that were up. The voters elected 7 new judges who we think will be dedicated to the rule of law, where the people they're replacing weren't necessarily. So maybe the Dallas Court of Appeals will start judging these trial courts' papers a little harsher. And harsher is not right. That's probably not the word I want to use. All we all want is just the rule of law, right? It's never been appropriate to refer to fighter jets and paintings as the value of something in a lawsuit, unless it's a lawsuit about the value of a fighter jet or painting. So we just need our trial courts to follow the rules, and we need the appellate courts to enforce the rules. And that's getting better. Houston, there were 10 of those appellate judges on the ballot in Houston in this election cycle, and the voters down there replaced all 10 with 10 new judges. In San Antonio, 4 were on the ballot, and there'll be 3 new ones in San Antonio. Corpus Christi, 4 were on the ballot. There'll be 4 new judges in Corpus Christi. So the voters are getting the idea that something's wrong in our judicial system, and they made some good decisions, we think, in this election cycle. And I think folks operating 18-wheelers and cranes and running grocery stores and nursing homes and everything else will see the benefit of the new judges the day they're sworn in, January the 1st of next year. It's a big change that our voters made for us, and I tell you, we should sort of collectively pat ourselves on the back as voters in these areas that voted for new judges, because they'll make a difference.
That's one part of it too, and I know that in Florida they capped it.
Yeah.
And in Texas it would be great. I mean, that would be the silver bullet, right? But can you talk about that strategy? Like if our voters are waking up to this circling the drain, issue of this inflation, the social inflation through litigation, do you think there's a chance for that to carry over into the legislature and push for something that's?
And let me second that too. That's a great. I think Florida actually capped pain and suffering.
Okay, yeah.
And you can talk about that, Lee, but also Lee mentioned when the jury gets questionnaires, they are 8 or 10 questions, and you fill out each line that could be $10 million apiece.
Yeah.
And Lee's talking about reducing those jury questionnaires down to maybe 2 questions.
Can you explain a jury questionnaire? I've actually, every jury I've ever been called in on, the case has been dropped. I've actually never served. So that's new to me.
If you serve on a civil jury, so let's say it's a trucking crash case, the typical, what we call a jury charge, but it's the questions you get after they close the evidence, they close their arguments, and now they've given you this packet of questions to go answer as a member of the jury. And of course, you go deliberate, answer this series of questions. So today, the damages question, how much should the plaintiff be awarded for his or her damages? What damage did they suffer? We'll have lines for please award past and future mental anguish is 2 different lines. Past and future pain and suffering, again, 2 more lines. So now you're up to 4 lines. Past and future loss of companionship, past and future disfigurement, past and future loss of the enjoyment of life. And so you can have up 6, 8, 10, 12 lines on the jury charge that the jury puts in a number for. And if they put in $5 million in each of those lines and you've got 12 lines, now you've got a $60 million verdict. The problem with that is, and disfigurement's a good example, it is certainly possible that in a collision you could be badly disfigured. And that disfigurement could cause you pain now and in the future. It could be something that's painful. It also could be that disfigurement causes you mental anguish every morning when you look in the mirror. I accept all of that as true. But it is unfair to have lines on the jury charge that ask you about physical pain, mental anguish, and disfigurement, because disfigurement is either mental anguish or it's physical pain. It shouldn't stand alone. And so when the jury's awarding physical pain, mental anguish, and disfigurement, it's doubling up. It's loading up twice. And so the jury charge really needs to be 4 lines: past pain, physical pain, future physical pain, past mental anguish, future mental anguish. And then disfigurement would be something that the lawyers could say to the jury, please include in your calculation of their mental anguish the fact that when the person looks in the mirror this morning, they feel mental anguish from that, which is legitimate, but it just shouldn't stand alone. So number 1, the legislature needs to fix the way those juries are questioned. And then number 2, like you're talking about, Gene, other states are capping pain and suffering and mental anguish damages. West Virginia capped at $5 million in trucking cases. So did Iowa. There are caps all across the nation. Many times the caps are closer to $1 million. But across the nation, legislators are capping these kinds of damages because they're seeing exactly what we're seeing in Texas, which is the numbers can get quite large, just really like that crane case, $860 million, which included 340 some odd million dollars in pain and suffering and mental anguish damage for the family of the person who was killed. I mean, again, they've got mental anguish. I get that. But $340 million is an astoundingly large number. And so other states are capping those damages. We can do it in Texas. The legislature can do it. But it will take the work of everybody out there in your listening audience for that to happen. But the caps are getting to be pretty common in other states, and the Texas legislature needs to think about it, in our opinion.
So we have a lot of small and medium-sized businesses. Our emphasis is crane and rigging, heavy iron, heavy transport. And we're getting this question, Ron, we cannot raise our prices because of competition. But if you look at our P&L compared to 10 years ago, it's tripled because of labor costs, because of insurance costs, because of equipment cost. And so it's really hurting the small businesses here in Texas with the litigation environment. And so what insurance companies do, if they have an adverse loss ratio, let's say during this last 12 months, they're going to spread the love around. And so you may have a really, really good claims record, but you still get hit with that increase because of what's happening with the litigation environment. We see it here every day. If we get a fender bender, and it may be our fault, we bumped into somebody, we're expecting a letter of representation shortly afterwards.
Yeah. Well, you've experienced it. That's because the lawyers have their people out on the phone calling whoever it is. But Ron, will you take an aside for me? What's you reference heavy iron? What does that mean?
Yeah, we kind of use that as a broad term. Heavy iron would be the steel erection businesses, the crane and rigging businesses, anybody that's around the heavy construction world, and we call heavy mainly driven by the crane rental business. But the steel erection business also, they have their own cranes. They're setting panel walls. So I use that term broadly, but it's really crane and rigging, heavy haul, and steel erection.
Well, so back to your point. You're right. Insurance companies are not going to lose money for very long. They're in business just like everyone else is, and so when they're paying out an inordinate amount to satisfy plaintiff lawyer demands, they're passing that through to their customers, the companies that are insured. My company, Texans for Lawsuit Reform, we're not working for the insurance companies. We're working for you guys who are out there paying the insurance premiums, because right now the insurance premiums are just killing you when you can get it. So the plaintiff lawyers are, everybody knows this, the term is deep pockets, right? Plaintiff lawyers are always after the people with the deep pockets. So if you're in a crane and rigging business, you probably have got potentially millions of dollars worth of insurance, layers of insurance stacked, because you must. Your risk is high. And so you've got a lot of insurance, and that is just too darned attractive to the plaintiff lawyers. So that's why they've got their case runners out calling people on the telephone after they've been in a fender bender with an 18-wheeler or whatever has happened on there. That's why they're pursuing these cases, is because there's money there. There's insurance. So the insurance now are getting more and more and more every day. Lawyer letters. Every time something happens, they get a lawyer letter. And the insurance companies are afraid of an $860 million verdict, like in that Dallas crane case. And so because they're afraid they'll get hit for an enormous verdict, they settle everything. And so when they settle everything that comes in the door, they are just putting more money in the lawyers' pockets. And the more money the lawyers have in their pockets, the more money they spend on advertising, the more money they pay case runners, and the more cases they generate, which then generate more settlements by the insurance companies, which puts more money in their pockets. And it's the circling the drain effect, Gene, just like you said. And that's where we are.
And it's amplified by the litigation funding, third-party litigation. That just pumps it up to 11.
Right.
That process you're describing. Yeah.
Yeah. The circling the drain is funded by the litigation funders who are getting tremendous returns. And so they're funding two ways. They fund the plaintiff lawyers' advertising campaigns. So if you're seeing somebody on television all the time, there's a pretty good chance they're borrowing that money from a litigation funder. And secondarily, they fund specific cases. So if they think a specific case is going to hit a home run, they'll put money into that case. And some of these funders, we're seeing now, some of these funders are sovereign wealth funds. Saudi and Chinese sovereign wealth money is in the litigation, is behind the litigation funders, the international litigation funders right now. So part of what's going on in Texas, this circling the drain effect, is driven by money that's coming from overseas to litigation funders who are getting 20% returns. So the whole process must change. We cannot continue to do this, because you folks out there that are working can't continue to pay the insurance premiums. And, so we've got to break out of this cycle. We have to give the insurance companies some backbone.
None of that has to be disclosed?
None of it. Right now.
Are you serious?
None of it has to be disclosed. That's right. Completely secret arrangements.
Especially foreign funds?
Foreign funds. So there'll be right now the Texas Supreme Court is working on a rule of civil procedure that would require funding arrangements to be disclosed in litigation. So if you're borrowing money against a specific lawsuit, you would have to tell everybody else in the lawsuit you're doing it. And then I think there'll be a bill in the legislature that says that foreign investing in lawsuits is unlawful in Texas. Not disclosure, you just can't do it. You can't use foreign money to finance litigation, either advertising or individual cases in Texas. And I would hope that that bill would pass the legislature with almost unanimity, right? You'd think everybody in the legislature would vote for that.
Sure.
We see the third-party litigation funding. We need to reform pain and suffering, cap that. We need to reduce that jury questionnaire from 8 or 10 questions. It's like monopoly money.
Yep.
10 million, 10 million, 10 million. I think we talked. Patrick Mahomes makes 500 million. Why can't we give 450 million to this poor plaintiff over here? And also just to get more involved. I mean, Lee, you talked about the Lone Star Economic Alliance. Lee mentions he can talk all day long to legislators down in Austin, but they hear from constituents, you and I, the small business owners, saying, I cannot operate my business because of the litigation environment. That may turn some heads. Am I right on that, Lee?
You're absolutely right. So, yeah, I work down here for a living, and we think we do good work, and we've got good relationships around the Capitol. But nothing matters to the members of the legislature like their own constituents calling them on the phone and saying, we need your help. And right now, you guys do need their help. We need to go get something done about this fraudulent medical damages. We need to deal with pain and suffering and mental anguish damages. We've got the ideas here at Texans for Lawsuit Reform. We've done the bill drafting. We know what will help fix the problem. We need to fix the trucking bill from 2021. We need to take out that amendment that's making it less useful than it could be. But we need you guys out there they're hauling loads, that are putting up cranes, that are working on construction sites. You all have to contact your members of the legislature and say, please help, vote for these bills. And so we've got the Lone Star Economic Alliance. It is our umbrella group. There's probably 40 trade associations in Texas that are members of it. The Texas Association of Business, the Oil and Gas Association, the manufacturers. And then we've probably got 800 companies and individuals who are members of the alliance. And the whole thing is for every member of the legislature to hear from their own constituents saying to them, we need your help. This litigation crisis is about to put us out of business. So that's really what I'd love to get out today is LSEA, Lone Star Economic Alliance, LSEATX.com is where we love for people to go, sign up. Doesn't cost you anything. We want your time, not your money. We want you to engage with your member of the legislature, and we'll help you do it.
Let's talk a little bit about how do we get bills passed in Texas? And Lee can correct me, but I think there's 19 Republican senators in the Texas Senate, and there's 12 Democratic senators, and it takes a 60% vote to pass a law. And in the House, I think there's 86 Republicans, Lee, and it takes 90 Republicans in the House.
Yeah. After the November election, there will be 88 Republicans in the House and 62 Democrats, and there will be 20 Republicans in the Senate and 11 Democrats. So both of those houses changed just a little bit in November. So the normal legislation, just the medical damages part we've been talking about, this fraud with the lawyers and the doctors just running up medical bills, we can fix that problem with simple majorities in both chambers. So we need 76 votes in the House and 16 votes in the Senate out of the 31 members over there. But if we want to cap the pain and suffering and mental anguish damages, and as I said, other states are doing that, that requires, because of our Constitution in Texas, we've got to have 90 votes in the House and 19 in the Senate. So we have to have a supermajority, 60% of both chambers to do the caps. And there's just no way we're going to get caps done if the members of the legislature aren't hearing from their constituents regularly and with a clear message that they need the help. So that's just critical to us for engagement from outside, from constituents. We've got to have you all out there helping us get this done.
Because you got to have 100% of the Republicans, and then you have to have 2 members of Congress from the Democratic Party cross over at peril
that won't be easy for them, right? That's a
No.
really, really hard vote for them.
Of course. Yeah.
Well, I think that House Bill 19 and 21, I think it was 19 Republicans and then 12 Democrats. So the 60% was there.
Yeah.
And so it's just getting on the phone or sending emails or contacting your local reps and saying, we got a problem here. And I think just getting the word out. So, well, that's every time we go into a client, Lee, they show us their P&Ls. We go, well, we're here to, as your insurance advisor, your risk manager, consultant, and they said, but look at the P&Ls. Look where the insurance cost is.
Yeah,
and it's probably its second line on the P&L.
Yeah,
we had somebody call us not long ago who said, for the first time in the history of their business, their general liability insurance costs were exceeding their employment right now, what's costing them to pay employees. Now that's a pretty extreme case. I'm not sure what underlies it, but everybody's telling us that their liability insurance premiums are just about to put them out of business. And I think we are losing some small businesses because of the litigation environment, and they just can't afford their insurance at this point.
Yeah, I made this comment before that before the hard market hit. I think we've been going through this since 2016 or 17, but
yeah.
It used to be, Lee, we'd go out and backslap and have lunch with our clients. Now you walk in, there might be 9 people in that boardroom. So we become very relevant in our clients' businesses. And I guess it's good and bad, but it's a big deal.
Right. Well, we're hearing it from all sectors of the economy. That's the thing. In 2021, we were really working on trucking because that's really where we were hearing that they were the target of the advertising TV lawyers. But right now, it's expanded to every segment of the economy, and you probably know this as well as I do. It's not just trucking, but it is grocery stores with slip and falls and apartment complexes with people breaking in and causing mischief. It is right now. We have to place children in foster care. There are bad parents out there, and children get taken away by the state, and they need care. And we've got a foster care system that's it's functioning with a broken leg too, because there's only 1 or 2 insurance companies that will write insurance for foster care right now. So those placement agencies can't get insurance, and what they're paying for that insurance is too high also, because they're suffering from the same litigation environment that the trucking companies are today. And we've got to have trucking companies delivering products. We've got to have cranes building buildings. And we've got to have foster care and placement of children with families who will take care of them. And so our society doesn't work without an insurance market that works. And right now, the plaintiffs' attorneys have managed, with the help of some trial judges, frankly, the plaintiffs' attorneys have managed to create a system that is out of balance, and we will not remain the economic powerhouse we are in Texas if this continues. We must get it under control. And part of the process, as I said, happened in November. The voters elected some better judges. Man, what a pat on the back we need to give all our friends who went and voted. And then the legislature needs to do its part and to give those new judges what they need to make sure that the outcome in cases are fair, balanced, and based on the rule of law. So we're making progress, but we can't do it without you guys out there that are listening today.
So you're in California, and you want to move your business to Texas because of the business environment, right?
Right.
Favorable business environment. But they don't call us and ask, which is a good jurisdiction, which is not. So nobody knows about the jurisdiction until you get sued, and then you get it into the courtroom with a judge that's going to not be favorable to you. And Lee, you said this attorney advertising, it's gotten really bad. Every time you turn on TVs, every time you can see a billboard, they're placing billboards right outside of our clients' offices strategically, because they all have big trucks and cranes. And I think you mentioned you guys are going to do some advertising.
Yeah. we cannot continue, just like you're talking about, Ron. The advertising by the plaintiff lawyers is ubiquitous. They sponsor the sports on every television station in Texas. They their names are on football fields in East Texas. They are advertising through every medium every day and spending a lot of money doing it. We on the business side are doing almost none of that to offset them.
Mm-hmm.
We are just not communicating it to the public at large. So yes, we at Texans for Lawsuit Reform think that we've got to go into an outward-facing communication strategy so that people understand the cost of what the lawyers are imposing today on our society. I mean, the price of toilet tissue in Texas costs more than it should because of litigation. And people need to understand how that works. And the only way you can do it is just to pay for the advertisement and start talking to people directly. So we'll start a campaign to try to get people to begin to realize that money's not free. When you put in $5 million in every blank in a jury charge, so that it adds up to $60 million, like I mentioned a minute ago, there are actual real world costs to that to everybody who buys goods and products in Texas. So we've got to start talking, and we're going to we'll get through the legislative session. I hope be successful in passing the bills we've been talking about, and then we're going to turn to some communication strategy to the general public to offset some of what they see on television every day, with the plaintiff's lawyer saying, "Call me first." I mean, right now we're coaching I tell this story pretty often. I went to Louisiana a few years ago to talk about what I do, except Louisiana wanted to know, how we were doing it in Texas. So I go over there, I get in an Uber, and the Uber driver, I'm driving along, I'm looking up, and they've got as many plaintiff lawyer billboards as we do. They're just everywhere.
Yep.
So I say something to the Uber driver about, "Man, you've got some plaintiff lawyers here." She says, "Oh yeah, my lawyer right now is a good one." She says, "I've been in 6 automobile collisions, and the first 3, my plaintiff lawyer settled the case without even telling me how much money. She just sent me a check. So I hired a different lawyer, and this lawyer's real good. He talks to me before he settles my case." And so, first of all, I'm in an Uber with a person who's had 6 accidents. So you're thinking, that maybe not the ideal. But then beyond that, what I get from that is that she has the sense that every time she's in a fender bender, no matter whose fault it is, it's time to go hit the insurance company for some money. And if our society continues to think that way, and the plaintiff lawyers are coaching them that way, call us first. It's their message. Call us first. Open 24 hours a day, 7 days a week. Call us first. They're coaching our society that every little event is a chance to go get money out of an insurance company. And if we continue down that path, we really will not be this nation's economic engine that we are today. So we just have an obligation, all of us together as citizens, to go fix the problem.
Do you sense any tailwinds out of the leadership in Austin?
I do.
For the upcoming legislative session on any of this? Is there anybody sponsoring, or some of the political arguing that's gone on within at least the Republican Party over the last couple of years? Are there any tailwinds that you sense to look forward to?
Yeah, I do sense a tailwind. First of all, let me say the Republican Party has had a little bit of infighting going on, but still, all Republicans, no matter which side of that little tiff they're on, support what we're talking about. Now, I say all. I mean, capping non-economic damages, getting all 88 Republicans in the House to vote for that, not easy. They'll want to talk about it in great detail. But as a general rule, all Republicans in Texas remain very business-oriented. They want the state to continue to lead the world as an economic center, and they know that this litigation is harming that. So I feel very good that Republicans generally are going to be with us on what we're trying to do. That's my sense. That's the tailwind I'm feeling. And I'll tell you, in South Texas, frankly, South Texas always had a lot of Democrat members elected to the legislature. And lots of those folks are pretty business oriented these days, those Democrats in South Texas, from San Antonio South. And so we do need a couple of votes from the Democrats, but we feel pretty good about that too. The trucking bill from 2021 passed the House with, I believe, 94 votes, which was 86 Republicans and 8 Democrats. Maybe it's 95 votes, 9 Democrats. So we got Democrats on the trucking bill in 2021. We'd still expect to do that. I think we should be reasonably optimistic that if we communicate with them broadly from the entire business community of the need for help, that we can get the votes we need, including some Democrat votes who realize that this it's out of balance. And that's one thing I haven't said, and I want to emphasize: you, me, any of us could be in a terrible accident tomorrow. We need it. We need to be able to go to court. We need to be able to address that in the litigation system if we have to. Our families may need it. What we're worried about are the fender benders where no one is hurt. We're worried about the fender benders where the person driving the car ran into the truck and then sues the truck driver. And that's what, Ron, I think you were talking about. You get lawyer letters in all kinds of cases these days. That's what we're trying to get under control, is the ones that are not legitimate lawsuits. The legitimate people still need their day in court. And I know we do at TLR. I'm guessing you guys do too. We all agree that if you're legitimately injured, you need your day in court. We just want those cases where the plaintiff lawyers are making it up to be out of the system.
We've got a poster child case, Lee, that happened to one of my clients. Bumped a truck in front of him, put a 2-inch scratch on a trailer hitch.
Yeah.
The guy gets out, and his 16-year-old son, man, he goes, great. He goes, exchange insurance information, and we're on down the road. We had a lawyer letter. Good plaintiff lawyer. Brings in a neuroscientist from the Atlanta Brain Institute and claims you can get brain tissue damage from a 5-mile-an-hour bump on the trailer hitch. And it's settled for $2.3 million.
That's exactly what I'm talking about. The 5-mile-an-hour crash just really can't cause the kind of injury that they will claim. And one of the similar kind of case out in East Texas, FTS was the trucking company. The plaintiff's name was Patterson. Just a little bump. Both the truck driver and Patterson get out of their vehicles, and they all say they're okay. They tell the local police they're okay. Monday, that's on a Saturday. On Monday, the plaintiff goes and sees a plaintiff lawyer there locally in East Texas. They run up $300,000 worth of medical bills and get a $101 million verdict out of a court in East Texas. Now, happily, the Tyler Court of Appeals is a good rule of law motivated court of appeals. It reversed the $101 million. But that's exactly the problem. When you're looking at the possibility of a $101 million verdict, paying $2 million in settlement begins to sound reasonable to you. We've got to let the insurance companies have a sense that they can defend their clients, they can pay the lawyers and defend the cases and have a fair chance to succeed in the lawsuit when it's not legitimate. And that's really our work at the Capitol.
Yeah. So when we talk to insurance partners, insurance markets, I think everyone to a T says, well, you're in Texas. Texas is a tough state for verdicts, for thermonuclear, nuclear verdicts. And we need to change that. And so Florida was a judicial hellhole for a long time, but they've made a lot of progress lately. And now the insurance companies said, we want to enter back into the Florida market.
Right.
And so we want to change that narrative, Lee, where we want to enter back into the Texas market.
Yep, you're exactly right. Florida did something in 2023. Particularly, Florida aimed at those made-up medical damages. So Florida's law now, after 2023, says that it doesn't matter how large a number the doctor or chiropractor writes down in terms of medical bills for a plaintiff's case. The only thing the jury's going to hear is 130% of the Medicare reimbursement rate. You can write down $1 jillion for a back injection for pain, but it doesn't matter. The jury's going to hear 100, whatever Medicare would pay times 130%. That's part of what we're working on in Texas. So yes, it's made a difference already. I saw a newspaper article yesterday or day before. Insurers are moving back into Florida. And when you've got competition in the insurance market, you get lower rates. And that's absolutely the key. It is like every other market has to be competitive. And to be competitive, the insurance companies have to feel like they've got a fair shot at a fair outcome in the litigation system.
Yeah. I mean, we talk to carriers now and they're going, $865 million on the tower crane claim in Dallas. So,
Spooks them.
well,
It
you
spooks
are
them,
very
right?
passionate. Yeah, you're very passionate, Lee. Texas for lawsuit reform is, it's awesome. I'm happy that you're leading this cause. This is music to our clients' ears, music for small businesses that, they want to move to Texas. Texas is a great state. We want to keep coming here, man. So, any last thoughts? We love having you on here because we heard you speak back at the TCOA, and I said we got to get Lee on as a guest, man.
Well, my only last thought is, again, lseatx.com is the Lone Star Economic Alliance. That's our umbrella group to get this done in the Capitol. So please, folks, go check out the website, join the organization, help us help you. That's really the key is we can get this done at the Capitol. We just need collectively, hand in hand, go to the Capitol and ask the legislators for help. So we're very motivated here at Texans for Lawsuit Reform. The Lone Star Economic Alliance is our, as I said, umbrella group, and we're very motivated to get that umbrella group operating successful and move this legislation. And we think it'll make a difference for everybody in Texas, all the way down to the people, as I said, buying toilet paper. You're feeling the pinch right now. You may not know it, but you are, of excessive litigation. And so let's just go do it together. I really appreciate you guys. Gene, Ron, it's been a real pleasure for me to be on with you today.
Well, we always kind of end it. What does Lee Parsley do outside being a lawyer?
Well, I am kind of handy. I was a farm boy, and my parents owned rental property in Lubbock, Texas, and I learned how to paint and do some minor electrical and plumbing and this and that. So I am a kind of a handyman, and I therefore right now am working on a project to remodel my kitchen, and that's what. And the days off, I'm down kind of in the wood shop making cabinets and going and putting them together in my kitchen. So it gives me, and I do it, and I don't think a darn thing about tort reform while I'm figuring out whether that board needs to be
Trying to keep your fingers on
trying to keep all 5 digits on both hands. Yep, don't think a thing about tort reform.
That is so therapeutic.
It is.
To get your mind off things, man. That is awesome. And we always kind of end with a kind of a light note. Gene's a big muscle car guy. What's going on with you, man?
I like to use tools as well. Let's see. Most recent update to the truck. I'm building a truck in my garage to my wife's. She's real excited, but we've made a lot of progress. The brakes are done. The steering is done. The fuel system is done because we put in an engine that runs off EFI instead of carbureted, and so next up is the radiator and the cooling, and then after that it's electrical. So my thought is maybe I'm driving this thing in January.
Oh,
maybe. I don't know. It could be next January. We're working on it. So and when I'm working on that thing, I'm not thinking about any of this either.
So Lee, just to let you know, Gene has triplets. He's got 3 10-year-old boys and a 7-year-old girl. So Gene keeps pretty busy with his car stuff and with the kiddos.
Oh yeah, I used to work on it a lot more than I do now, but the kids' schedules are, kind of all encompassing, right? Don't have as much time. Saturdays and Sundays used to be for, whatever, tinkering, working on projects, and now it's covered up in cheerleading and baseball tournaments and all that other fun stuff, which I'm not complaining about. I love it all. So anyway, but yeah, we're making progress on the truck, to my pleasure, and especially my wife's happy about it too.
well, I had 2 brothers, so there were 3 boys in my family. We weren't triplets. We were pretty close together. And really, my parents had to take out a bank loan about every year when we were 15, 16, and 17 just to pay the grocery bill. So you've got, we ought to all put a little money into Gene's retirement fund or something, because his grocery bill is going to be pretty big in about 4 or 5 years.
You should see them, the number of gallons of milk in our fridge right now. The provisions, the groceries have to negotiate for space in our fridge. And every week we start over. Yeah, that's funny.
Now, just hope the triplets get D1 scholarships from Baylor.
You know what? They better, because I can't afford that place. there's no chance, So anyway, yep.
Yeah, and I always end with kind of a movie geek. I don't have much time to watch movies, but and I want to see this latest Taylor Sheridan episode called Landman, and it's about the Permian Basin and the oil, the ups and downs. It's based on a podcast called Boomtown, and anything with Billy Bob Thornton, count me in.
Yeah, sure.
So I haven't seen it. I want to see it. I heard it's great. Another Taylor Sheridan production.
Yeah. Well, and you know what? Our guest a month or two ago, Chad Ginger, he had one of their cranes on one of the episodes.
Yeah, we had a client that had their cranes on set, Lee. We had a client in Burbank, California that did all the Terminator movies and had their cranes crashing into the trains, and the underwriters called me and says, "What the heck are we doing crashing into trains on Terminator?" I said, "Well, I'm sorry, I had the big name on the boom section." But anyway, hey man, it's been a pleasure.
Yeah, thank you.
Love having you on here, and when we heard you, we got to get him. So I really appreciate your time.
Thank you, guys. Have a great weekend.
Yep, you do the same.
Hey, Lee, really quick as we sign out, let people know where they can find you again, and give us that website one more time.
LSEATX.com. That's for Lone Star Economic Alliance. So LSEATX.com. Thanks again, guys.
Sure thing. And we'll have that link down in the show notes below. Thank you, everyone, for listening, and be sure that you subscribe and leave the show a 5-star review. If you have any questions, you can reach out to us by following the link down in the show notes below. New episodes go out each month, and we are now on YouTube, so audio listeners, be sure that you go over and check us out over there. Until then, we will see you next time.